Good morning, everybody. Welcome to the First District Court of Appeals. We have two cases to be argued today. I'll call the two cases. If counsel could introduce yourself and indicate your readiness to proceed. First case is Morgan versus Jones.
May it please the court. My name is Chrissy Dunn Dutton, and I've actually just entered a limited scope representation appearance on behalf of the appellant, defendant Mark Jones, and on behalf of the trustee, Mark Jones.
Okay.
Your Honor, Michael Lasso on behalf of Victoria Morgan, Aaron Wilkins, my co-counsel, will be the one that argues today.
Okay, great. Thank you both. And then the second case is Claiborne versus Mercedes-Benz.
Good morning. My name is Scarlett Stewart. I'm representing Maurice Claiborne.
And good morning, Your Honor. My name is James Bedell. I'll be representing Mercedes-Benz USA LLC.
Okay, great. Thank you both. Okay, so for Morgan versus Jones, counsel may come forward.
You're ready for me to?
Yes, please, please. And would you like to reserve any time for rebuttal?
Yes, Your Honor. 2 minutes, please.
2 minutes, great. And you may proceed when you're ready.
May it please the court, as indicated at the beginning of just a moment ago, I have recently been retained to enter a limited scope representation appearance on behalf of appellant Mark Jones, as well as the trustee of the Mark Jones
So does
Trust.
that then acknowledge that the trust was improperly being represented by Mr. Jones in his briefing?
Yes, Your Honor, I do believe that it would be, the trust would need counsel to make the arguments on behalf of the trust. However, Mr. Jones also appealed in his individual capacity as the defendant in the divorce case, and this was an order entered in the divorce court only, of which the parties are the wife and the husband, appellant and appellee here. For purposes of the appeal, though, I would represent to this court that my client is currently incarcerated in the Hamilton County Justice Center. On October 10th, he was picked up on a body attachment order with respect to the contempt orders issued in this case, and therefore I was only recently retained to appear in this oral argument to represent to this court that he would like to submit on the arguments made in the briefs. And I have reviewed the briefs, and I have reviewed a fair amount of the procedural history. However, it is a pretty lengthy case, and given the time constraints as stated in my appearance, I don't think that under the time constraints I'm able to independently verify the facts or legal arguments made. However, I do understand the arguments to the extent that this court has questions as to what Mr. Jones is arguing. If it would be of help to the court to clarify any of the points he's making, I believe I have a good understanding of what he's trying to argue to the court and to represent what he is asserting to the court. But otherwise, he would just ask to submit on the arguments in his briefs. And I do want to reserve the 2 minutes for rebuttal
Okay.
in case anything needs to be clarified.
Okay, any questions? Okay, thank you.
Thank you, Your Honors.
Good morning, Mr. Galasso.
Good morning, Your Honor. May it please the court. So I think this has been briefed, and I know the court has obviously read the briefs. What I just wanted to do is just see if I could succinctly get to the point, which is the appellant's brief is lengthy, but the assignment of error itself, which is really all the court's got, is just, it's basically a due process argument, and it's a notice argument. He's claiming that he didn't receive notice of certain proceedings or that certain things weren't served upon him, but it's done in a cursory fashion, and there's really no evidence to support any of that. But in the background, is, as Ms. Dutton said, is there was a body attachment issued for him, and so in order for him to not appear in court, where he would obviously have to deal with that issue, he deliberately evaded the court and made all these requests to appear remotely, which originally Judge Tolbert and then later Judge Sunderman denied, and he was required to appear in person. So the record is clear that he's, excuse me, he's gotten notice of all of these proceedings. He's had an opportunity to be heard. He was properly served. I believe that his actions on behalf of the trust are a nullity because it's the unauthorized practice of law, and that would extend to the notice of appeal to that extent. So that's kind of the context of his assignments of error, and I think it can just be boiled down to a simple due process and notice issue. With respect to the lengthy history, it is lengthy, but it's kind of concise as to what's left. What happened is the court appointed a receiver, Ms. Zumo, to sell this property, and she had been really exasperated, I think, by the time I got involved. But they were unable to do so because Mr. Jones's trust owns 2/3 and Ms. Morgan's trust owns 1/3. And his 2/3 interest became encumbered by about a $40,000 judgment lien to American Express and then about an $80,000 or $90,000 judgment lien to a law firm in California. So they were unable to convey clear title. And so at that time, Ms. Morgan, who desired to have this property sold and has been trying to get it sold for the last 4+ years, was subject of a tax foreclosure case in the Common Pleas Division. And Wells Fargo, who is the mortgage holder, who hasn't had their debt serviced in all this time and is advancing real estate taxes and insurance and other amounts, and obviously the equity, to the extent it was ever there, is now gone, not just because of the judgment liens, but because of the mortgage. Wells Fargo then advanced $100,000 to dismiss the tax foreclosure case. So effectively, that $100,000, which would have only gone against the property, then became Ms. Morgan's individual liability. And at that point, there was a bit of a press to get this property sold because without it, her liability continues to increase as Mr. Jones frustrates the sale of the property. And so the only way to get all of the parties into the case was to file a complaint to sell real estate in the general division. So that's what happened. 273504 gives the receiver the power to sell. It was also in the order itself. And so you name the parties that are in the preliminary and final judicial reports, they're all named. The state of Ohio, I think, disclaimed because all those liens are people with similar names. But Judge Marsh observed the lengthy proceedings in the DR court and decided that it was best that the case be transferred back to the DR court. So sua sponte, that happened without any motion of the party. So when we got back there, we have now the A case back in the DR court and the DR case. So there was an order that eventually defaulted out the trust because it never responded to the complaint, and it also approved a receiver sale of the property. And then in the same entry, the one that he's primarily appealing from here, it put out an order consolidating it. But that was necessary to go to the general division because otherwise there was no way to get the lien holders in there to have a free and clear sale. So that's kind of the history of how we got here, but the sale order is...
And there's no issue regarding the propriety of the transfer to DR court, right?
I didn't challenge it, and neither did anyone else. And I will say to Judge Bergeron that American Express defaulted, Fifth Third defaulted because they have a satisfied but unreleased lien, so it's kind of neither here nor there. But
right.
The attorney for the law firm that's the lien holder participated, consented to the sale. Wells Fargo consented to the sale. Everybody wants this thing to go forward but
right.
Mr. Jones. And so, otherwise, the only other thing that I had on my list that was in his brief was he's also attempting to, again, appeal a different order in addition to what I will concede is a final appealable order, which was the sale order. That's final appealable order. But the other order, substituting receiver, I think would need to wait until the proceedings are complete. He then argued in his reply brief that it's interlocutory, so it merged into the final judgment, but this isn't a final judgment. This is just, it's a final order because of 250502, and it's specifically listed in the statute as affecting a substantial right. So the sale order is final for that reason, but it didn't make all these other things final. And even if it did, there's no challenge to it other than he doesn't like it. I mean, the original receiver was substituted, and I'm just not sure that there's anything in the brief that raises any type of legal error.
Okay, great. Thank you very much. Ms. Dutton, maybe for your rebuttal, if you could just discuss, your client is making a due process argument, and so is there not evidence in the record that he did receive notice of these proceedings?
Your Honor, I think that the understanding that I have of the procedural history is the divorce case was filed. There was a decree of divorce that went on and indicated that the parties would receive the proceeds of sale in proportion to their tenancy and common interest, which was 67% in favor of Mr. Jones and 33% in favor of Mrs. Morgan. Later, in the common pleas court, in a case in which Mr. Jones was not named in his individual capacity, and he also maintains that he was not served with the motion, the complaint in that case.
Right, he maintains he wasn't served, but what does the record show? Does the record show that he was actually served?
The record shows that the trust was served as a party with that motion via the.
But the
property.
trust is the one that held the ownership interest in the property, correct?
Yes, Your Honor, for which he is the trustee and beneficiary. So it's a revocable trust for which he is the beneficial owner. And for which the divorce decree indicated, it didn't mention the trust with respect to the proceeds of that sale. I think everyone, in that case acknowledged that they are the parties who have the beneficial interest in these properties. And if the court, if they don't have an interest in their individual capacities, then the DR court would not have jurisdiction in the first place to enter this order. So it is an absurd result, I think, to state that he doesn't have standing in his own divorce case, or else this should have been decided in common pleas in the first place. It wouldn't be appropriate to decide this sale order in the divorce at all if we didn't all acknowledge that he's the beneficial owner of this property. With respect to the notice issue and the due process issue, it is true that there was a body attachment order, but Mr. Jones also was residing in California about 2,000 miles away. And the notice that he received was that this was a status conference. Again, without fully having reviewed all the transcripts, this is the part that I'm unable to, verify. But my understanding is that there are transcripts. Some of the transcripts in the later part of 2023 did not have a recorded transcript. However, there were motions made orally to I guess, substitute the receiver and to enter this judgment pursuant to the consolidated case order. However, the complaint in the common pleas case actually asserts that the trust has 2/3 of an ownership interest. The Jones Trust has 2/3 of an ownership interest, and the Morgan Trust has 1/3 of an ownership interest. So to default out Mr. Jones, even if we accept that the consolidated case brought both cases properly before the DR court, and that the notice of a status conference in the DR court would be effective notice of the unserved motion for default judgment on the trust, even accepting all of those issues, it's not proper to default out the interest when the complaint itself didn't allege, make any allegations that the proceeds shouldn't be distributed to the trust in the proper order of priority. Furthermore, one other point that should be made is Mr. Jones is not attempting to impede this sale. Mr. Jones wants nothing more than to sell this property. His objections to the sale are that it was, as he referred to it in his brief, a fire sale. The original offers that were rejected.
Then he's trying to impede the sale. I mean,
No,
like
he
you
would like
can't,
to access-
I mean, I understand your point. At some level, he wants it sold, but he wants it sold on his terms rather than the terms that the other parties are amenable to. So, he can't have that both ways.
Well, he would like to exercise the buyout option of purchasing her 1/3 tenancy in common interest, which is referenced in the decree.
I mean, then he should try to do that, but that's not something that's before us at this point.
Your Honor, that is what he is attempting to do and why he objects to the sale in this manner, because he wants the property sold either, for the market value pursuant to the decree, or he wants to exercise the buyout option.
Right.
But wasn't that what he was supposed to do 6 years ago, when he was ordered by the court to do so? Wasn't the court, they couldn't agree, so here we are today, 6 years later.
Your Honor, my understanding is that there was no disagreement as to the buyout option, because I believe the sale was stalled when
Well, he's had the right of
market
first-
value was never established through
Well,
the.
he's had the right of first refusal since 2018, I think. I think that was part of the decree, I recall that. And so if he had the right, it seems like he would have exercised it over the course of these past 6 years. At least to me, it does.
Yes, I would represent to this court, Your Honor, that he would maintain that he is attempting to exercise that right and has been
You better hurry up then.
ignored.
Okay, you're at your time, so thank you for
Thank
your
you, Your
argument.
Honors.
Yeah. Thank you both for your arguments today. The case will be submitted, and we'll get a timely written decision, and hope you both have a great day. All right, the next case is Claiborne versus Mercedes-Benz. Yes, please. Ms. Stewart, would you like any rebuttal time?
I'll save 3 minutes.
3 minutes, okay. You may proceed when you're ready.
Thank you. May it please the court, opposing counsel, my name is Scarlett Stewart and I represent Maurice Claiborne. This is a case where the trial court erred in granting summary judgment on defendant's motion on all claims for a vehicle that would not start, even though it was subject to repair 4 times and in the shop for 40 days. For clarification, plaintiff did file his own motion for summary judgment. We are not appealing that decision. We are only appealing the trial court's decision related to defendant's motion for summary judgment.
So you've got the no start issue and the unlock issue, and you, like, they get kind of jumbled in the briefs about like which one is at what point, but like these are two different problems. Like, I understand that there may be some commonality that might link those with a fuse or whatever. I don't understand cars, but like, ultimately, do you not have to prove that each specific problem satisfies the elements independently?
Correct. So this is particularly why I wanted to come have oral arguments today. There are 2 different issues. They seem to be tied to an extent, but not necessarily. And I agree that if Mr. Maurice wants to maintain a claim for a lemon law or breach of warranty as to the unlocking defect, then he needs to meet the elements of the lemon law or the breach of warranty claim for that specific issue. So for each issue, he would need to meet it. I believe in the trial court's decision, these 2 issues got tied together, and I believe that's because they're happening at the same time. There's not a situation where it's not unlocking right, but then starting. It's kind of happening tied together. And so I think because of that, that created some confusion with the defects. But he does have 2 distinct defects.
And you're not arguing them together, because it looks like the 2 defects were ultimately repaired with that new part that they put in, right?
Right, so
And
the one-
everything was settled at that point.
Yeah, the one fix seemed to address both issues.
But you're not arguing both issues are interrelated because they were fixed by the one fix?
No, because
Okay.
I think the big driving issue here that I think if you read Mr. Claiborne's deposition is the no start, the fact that he can't leave work and drive home. Yeah, it's very frustrating when his car won't unlock, but he was able to, there's like a manual way to unlock it.
So you wouldn't argue that the no lock issue was a substantial impairment?
No, I don't think that is his problem. And because he could unlock it manually,
With the alarm
the fact
going
that
off?
yeah, I mean, it's still incredibly frustrating. But if he could have unlocked it and started his car and drove away, I don't think he would have proceeded through this. It's the fact that he wasn't able to start his car and go home after his 12-hour shift on a couple occasions that is driving him. And I feel that that kind of interrelatedness caused the trial court some confusion. And in reviewing the trial court's decision, the court primarily focuses on this unlocking defect on pages 2 and 4 of its decision. What you don't really see a discussion of is the unlocking issue and the amount of times that it was presented for repair and the number of days it was presented for repair. So under revised code 1345.6, 7.3A, it lists 4 different ways that a vehicle can be a lemon.
Oh, hold on a second. You're talking about the unlocking issue now?
No, I want to just
Or the
set
no start?
unlocking issue
Put that aside. Okay, so
Yes.
you're talking about because I thought you said no unlocking issue, so.
And if I did, I'm sorry.
Okay, so the no start issue, you're saying was submitted for repair
4 times
4 times?
in 40 days.
Okay.
And it would meet the presumption of a lemon under either subsection A1 or A2. And I think what's important here to note is that Mr. Claiborne does not need to meet all 4 or 2 of them. He only needs to meet one of them for the vehicle to be.
Can you explain what are the dates specifically that the no start issue was brought in for repair?
It was brought in on February 17th, 2021. That would be the first time to Mercedes-Benz for 1 day.
Right?
It was brought in on November 4th of 2021 to Mercedes-Benz for 1 day. I think where that confusion comes from is he had experienced the problem the night before, so you'll hear reference of
Right.
November 3rd. And then he brought it into Mercedes-Benz of Fort Mitchell for 2 days on November 11th, 2021. That incident that prompted that appointment happened on November 6th. And then he brought it in for the 4th time to Mercedes-Benz of Cincinnati on November 29th of 2021 for 36 days.
And you're saying on all 4 occasions, he tried and was unable to start his vehicle? Is that what you're saying?
Actually, Your Honor, he brought it in complaining about the no start unlock, but when I was reviewing his plaintiff's answers and depositions in anticipation for today, a close reading actually makes it look like I'll refer to the repair order dates because I think that's a little bit easier. On November 4th and the 11th, on the 4th, he testified that he was able to manually unlock it, but the alarms were going off, so he didn't start it. And it's a little unclear from there whether it didn't start or he didn't try to start. So I just want to be frank with the court. And then
Well,
on,
I guess that's where my question was going. Like, it seems clear, based on what he said in his deposition, that one of these dates, the 4th or the 11th, they weren't trying to repair the no start issue. That's my question for you. Like, was he acknowledging in his deposition that the no start issue was not an issue at one of these repair dates?
and upon second read, it seemed a little unclear to me. And how I will kind of address that is even if both November 4th and November 11th, it was not there for the no start, he still meets the presumption of 30 days out of service because on 11/29 of 2021, he took it there and it was there for 36 days for the no start issue.
So is it your position that if you hadn't had chronic issues, you just bring the car in because of something's going on with it, and it takes beyond 30 days, that's sufficient to establish a lemon law?
Correct. I think Royster really highlights that section of the lemon law where it talks about the fact that a vehicle is out for 30 days. That is what makes it a lemon, the fact that they're deprived of the vehicle.
Let me ask you, ma'am, it sounds like the issue's been remedied when they found the pins that were separated. So what is, does Mercedes-Benz, are you arguing they still have to purchase the car back, or what is he looking for?
Yes, I believe he's still entitled to remedies under the lemon law,
Okay.
or even if a jury was to find maybe it doesn't rise to the level of a nonconformity or something, he would still be entitled to remedies, which is generally cash under the breach of warranty.
But tying off Judge Winkler's questions, what remedies? Like, what are his damages that he could reasonably, like, if you win, go back to a jury and reasonably ask for?
So under the Limbin law, he would be entitled to ask for a repurchase or a replacement. And that, I think, is supported by the Royster case, because in that case, there was an engine defect that took more than 30 days. My recollection was it was about 40 or 45 days. And then it was remedied. And so when the Supreme Court was looking at it, that vehicle had been fixed for quite a long time. Yet the court was still saying the Limbin law is designed to protect consumers in these situations, and the fact that a vehicle is out of service 30 days, that is what makes it a limit. The fact that the consumer has been deprived of the ability to drive their vehicle for 30 days.
Did he get a loaner or anything during that time? Or did he have to?
He had a loaner on like one or two of them, but not all of them. The 30 days out of, when it was 30 days out, I honestly cannot remember, Your Honor.
And how do you respond to Mercedes' argument that the 30 days should be told due to the COVID-19 supply chain problem?
In two ways. First is, in contrast to Fagan, which was a decision against Jaguar Land Rover that came out of the First District, I believe in 2023, that was a situation where the service manager in that particular case had been out with COVID. There was evidence of it. And that situation happened kind of the prime time of COVID. It was March to April of 2020. In this case, we're talking about a supply chain issue that happened almost 2 years later. And I think that's a question of fact for a jury to decide whether a supply chain issue, when Mercedes-Benz is still making plenty of new cars, so these parts are available, whether that meets a definition of a natural disaster. Because that section of the Limbin law does not say because people are sick, because you don't want to put parts towards warranty repairs as opposed to new vehicles that you can sell. So I think that should have been a question of fact for the jury to decide. However, the trial court actually doesn't seem to really address that in this decision. And I think I'm getting close to my time. So the last thing I just want to touch on is the elements of a breach of warranty in Mag Moss are different than a Limbin law. I think IMS makes that clear when it talks about if you have a Limbin, you probably have a breach of warranty, but you can have a breach of warranty without meeting the additional requirements of a Limbin. I will reserve the remainder of my time. Thank you.
Thank you. All right. Mr. Fidel? Morning.
Morning. May it please the court, opposing counsel. As I stated earlier, my name is James Bedell, and I represent Mercedes-Benz USA LLC. Now, there is one fact that is dispositive to this appeal that I want to highlight, and that is that Mr. Claiborne's vehicle did not have a nonconformity, as that word is defined under Ohio law. A nonconformity in Ohio is a defect that substantially impairs the use or safety of the vehicle. Now, interpreting from opposing counsel's opening argument that
And I think like her whole point is that's a jury question. Like, how do we evaluate that question without stepping into the shoes of the jury?
And I think it's a bit of a threshold issue in the sense that opposing counsel and Mr. Claiborne seem to want any defect, any allegation of defect to be a question of fact when it needs to raise to a level of severity in order to be considered.
She's focusing here on the fact that he couldn't start the vehicle. Now, wouldn't that impede your use of a vehicle, not being able to start it?
If your car never, ever started,
Well,
I would probably agree.
I think but I think Judge Cross's question is, it's not just never, ever start, then you can't even get it off the lot, right? But it's, if there is a chronic issue where the car is not reliably starting, that does seem to substantially impair the value, use, et cetera, of the car, right?
And if it were a chronic issue, that might be an interesting question. But in this case, it was not a chronic issue. Mr. Claiborne testified at his deposition that a grand total of 2 times he was unable to start the car.
But hold on a second. So, I mean, I'm just trying to understand how we evaluate a Limbin law claim. So we look at whether this was like a substantial defect, right? And then you either have the multiple repairs or you have that it was in the shop for more than 30 days. So he had a no start, he couldn't start his car. You're arguing it's not a substantial defect, but also it was in the shop for more than 30 days, right?
So that is also another, that's a good question, because one other thing I'd like to clear up for the record is that during the fourth attempt, during the fourth time that Mr. Claiborne presented his vehicle for repair, the Lemon Law only allows for if the car is out of commission for 30 days within the first year of ownership. So I believe opposing counsel said that on the fourth trip, it was in the shop for 36 days, but only 29 of those were within his first year of ownership. So I believe that even the 30 days doesn't matter here, because Mr. Claiborne does not satisfy within his first year of ownership. Now, to back up.
Only 29 of the 30, how many days? You said his car was out of commission for how many days?
So that was, on the fourth trip, it was 29 days, and on that day, the car was still in the shop, but his first year of ownership had expired. And the Lemon Law only covers how many days the car is out of commission by reason of repair within the first year or first 18,000 miles, whichever occurs first.
So your argument on the COVID tolling wouldn't even matter with that?
If that's if you
Okay.
accept that interpretation,
All right.
we don't even need to reach the COVID issue.
Okay.
I think the COVID issue, to me, sounds like a stretch, given the timing of it. I mean, it'd be one thing if this was under, like when we had tolling orders from the Ohio Supreme Court, and we had governmental restrictions on COVID in early 2020. We're talking about the end of 2021. There weren't any such restrictions that I'm aware of.
And for that, what I would say is that, when you talk about supply chain, we're certainly.
I understand supply chain issues, like we're all aware of that, but like, unless you can point me to something that says some supply chain issue operates to toll this, then I think it might be best to focus on other arguments.
Sure, we can put that aside for the
Yeah.
moment, because I do want to get to Judge Krause's question regarding, a defect, and at what point does it become a defect? Mr. Claiborne complained that he could not start his car. One thing I also want to clarify for the record is that his car can be started in multiple ways, and it seems that his chief complaint was about his inability to start his car using the application on his phone. But he testified that when using the more traditional method of pushing down the brake and hitting on the start-stop button, that often created better results for him, as evidenced by the fact that of the 4 times he presented his car to a Mercedes dealership, he drove his car to 3 of them. And he even was able to take liberties such as postponing the day by which he would bring the car in based on availability of loaners, or based on his own personal schedule, based on regular maintenance intervals. There was one situation in which he delayed it because he'd already been scheduled for his 10,000-mile maintenance, and so he figured, I can still drive the car in the meantime. I don't need to take this in right away.
So is your argument that it's not a substantial defect because sometimes he could start the car?
My argument is a little different.
Okay.
It is that it is not a substantial defect because virtually all of the time he could start the car. He was only precluded from starting his car for a period of, I believe, about an hour or so in February 2021. Every other time, he was able to start the car and enjoy the full use of it entirely.
Did he get a loaner car on that 36-day period?
Yes, I believe he did.
Was there a key, what I call metal, the old traditional metal key within that fob that you could take out to start the car as well?
That's correct, yes,
Did he
and
ever
that
use
always worked.
Did he ever use that? Used to start it?
He would on certain occasions. There were times when it seemed like he just preferred not to, and so he would leave the car unlocked. But from his testimony, there was never a situation in which he was unable to unlock the car. At least one of the methods always worked.
It
What
just
about
would set
starting?
the alarm off, right? Isn't that what the problem was, and that's why he left the car unlocked?
At least one instance, he did mention that it may have started the alarm when he did that.
Okay.
Now, one other issue I would like to address here is regarding the other claims, the Magnuson-Moss Warranty Act and some of the other warranty claims that Mr. Claiborne has brought as well. Now, I don't disagree with opposing counsel that there are different elements that need to be met there, but at the same time, they do not reach the main element, which is that you need to show a major defect. That part aligns with the Ohio Lemon Law, and that is the part of the Ohio Lemon Law and the Magnuson-Moss Warranty Act that Mr. Claiborne cannot satisfy, because there, for the same reasons as I just mentioned with the Lemon Law, there is no substantial defect.
But in the Magnuson-Moss warranty claim, the reasonable number of attempts is not defined, right?
That is correct.
That would be like a jury question.
So in that particular instance, and that actually raises a great question that I meant to address earlier, which is that this reasonable number of attempts, it seems that opposing counsel is arguing that if you can meet this 30-day threshold, at least in this particular example, this 30-day threshold, that you automatically can qualify for a Lemon Law, but that kind of rewrites the Lemon Law. The Lemon Law imposes liability against a manufacturer when a nonconformity is not repaired within a reasonable number of attempts. And the 30-day provision falls into a subsection of the law which defines when we presume a reasonable number of attempts has occurred. But if you back up to the main portion of the statute, you still need to show that a nonconformity was not repaired within a reasonable number of attempts. So if we're not talking about a nonconformity, it does not really matter whether we've presumed a reasonable number of attempts has been made, because there's not a nonconformity, and that does not entitle relief under the Lemon Law.
That's the threshold issue under the Lemon Law, is the nonconformity.
Yes, that's
of it.
correct.
And you're saying same thing for the Magnuson-Moss warranty.
That's correct,
claim.
yes. If there is no nonconformity, all of our discussion about how many days it's been out of commission and everything like that it's just not a question this court needs to reach if there's not a nonconformity with the vehicle. Lastly, I do want to, this was not quite addressed on opposing counsel's argument, but regarding the CSPA claim, Mr. Claiborne has brought a CSPA claim. Now, the CSPA in Ohio is a statute that sounds in fraud. That is situations where there's a warranty presented and hypothetically the manufacturer does not honor it. The facts do not support any relief under that statute here, because every time Mr. Claiborne brought his vehicle to Mercedes, they inspected it, they took it in, they provided loaners when available, they honored the warranty, and even at his deposition, Mr. Claiborne acknowledged that he felt that they honored the warranty. Whether he wants to have a question about the craftsmanship or the timing or anything about that is not CSPA territory. This is simply about whether Mercedes fulfilled its obligations under its warranty, which Mercedes believes it did, and Mr. Claiborne has agreed at his deposition. And unless the court has any other questions, I believe that's all I have.
Great. Thank you very much.
Thank you.
Sir, you have 3 minutes for rebuttal.
Just a couple of things to touch on. First, it seemed like in opposing counsel's discussion, he started intertwining that unlock and no start issue again, saying, well, he could manually unlock it. Again, that's not where I'm focused today. There were 2 times where he testified he was not able to start the vehicle and the alarms were going off. That's on February 17th and November 29th. So I just want to make that clear. Otherwise,
So there's only 2 times that he was not able to start the car.
and I'm defaulting back to that because the other 2 times in reviewing his deposition and stuff, it became a little unclear to me. So I'm trying to stick to what for sure he testified to. And otherwise, Mr. Bedell's arguments all really relate to questions of fact. Did it rise to the level of a nonconformity? Did it meet the definition of, or a presumption under the Lemon Law? So then Mercedes wants to focus on the number of days and kind of say, well, it wasn't actually that number of days. It was 29 days as opposed to 36 days. That's a question of fact for the jury.
Well, I mean, is he correct that the 29 days only 29 of the 36 fell within the first year of ownership?
No, he's not correct, because also you have the time where he took it in on February 17th, which adds another day to that. The lemon law does not require the 30 days be consecutive.
Sure. No, I understand that, but the question I was asking is, of the 36 days that was in on that last repair effort, your opposing counsel says only 29 of those fell in the first year, and I understand your argument, like, well, wait, there's other days, but my question is more precisely, is that correct that only 29 fell within the first year? And if you don't know, that's fine.
I thought it was more than that. I know he took it in on 11/29, and his first year would have been up on 12/27, because that's when he bought it. There's the extra day in December for 31. So I believe, kind of quick math, that does sound like 29. I know.
But whatever it is, like, I mean, that's
Right,
that's
right. Those are
a
the
calendar
days.
issues that we can figure out.
Yeah, those are the dates. I know the lemon law does talk about even if it was worked on after the fact. So I think there's mostly questions of fact here of whether it rose to the level of a nonconformity.
And so I just want to be clear, because your brief argued both the no unlock issue and the no start issue. Are you conceding that the no unlock issue does not rise to the level of a nonconformity by itself?
Yeah, he
Okay.
was able to eventually get in the vehicle manually, so he was able to unlock it. The situations where he could not start it, he tried to do it manually and could not start it. He had to call a tow truck on the 11/29 attempt. And the other time, he had to sit there for two-ish hours before it would work. And in the repair, Mercedes acknowledged that it's an intermittent connection issue. And so I think the jury would need to be tasked with deciding whether the no start issue rose to a nonconformity. And so I'd ask this court to reverse and remand.
Great, thank you.
Thank you.
Thank you both for your arguments today. The case will be submitted. We'll get out a timely written decision. Hope you both have a great day.
Thank you.